I'm ready on green. I thought there was a complainant on green. I'm ready on green.
Officer Kraft just went in the hallway for.
All right, this is case number. I don't know why y'all have them sitting in the hallway. Case number 194444501. The people of the state of Michigan versus Nicole Green. Defendant is charged with 1 count of failing to report an accident and 1 count of driving while license suspended, revoked, denied. Today is the date set for for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and I believe the complaining witness is in person. There he is, Judge, in the courtroom. Sir, can you state your name for the record, please?
My name is Michael E. Reeves.
And for the record, Your Honor, Janice Stevenson, appearing on behalf of Ms. Nicole Green. Ms. Green, ma'am, please tell the judge your full name.
Nicole Green.
Today is the date set for sentencing. Court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
Your Honor, I'm looking at the pre-sentence report. We don't have any additions, deletions, or corrections at this time.
Any additions, deletions, or corrections on behalf of the defense?
Your Honor, Ms. Green and I have had the opportunity to review the pre-sentence investigation report. We find it to be factually correct. We have no additions or deletions at this time.
With respect to sentencing, is there anything on behalf of the people?
Judge, so I'm looking at the recommendations from probation. I see they recommended a probationary term for 12 months. They also recommended 6 weeks of anger management. I'm going to actually ask the court to amend that to at least 12 weeks, just due to the nature of the charges, Judge, and the description of the offense listed on page 4. The other recommendations, Judge, I'm just reviewing. I see there's a driver improvement program that was included in the recommendation, which is fine by the people, and 5 days of community service. I'm going to ask the court again to amend that to at least 1 week of community service in this case, Judge. Other than that, Judge, the complainant witness is present in person. I understand that probation did contact Mr. Reeves and he did give a victim impact statement on page 4. So I'm going to ask the court to just review that victim impact statement, Judge, and then Mr.
I don't have a victim impact statement. Oh, you mean that's
or the
on
victim statement. I'm sorry.
Oh, okay.
I'm sorry, Judge, the victim statement. Let me correct myself. There's a victim statement. If there is anything additional Mr. Reeves would like to add to that, Judge, I would defer to Mr. Reeves. Also, Judge, regarding restitution, it says to be determined. I'm assuming that was based off the conversation that the probation officer had with Mr. Reeves in the victim statement. So I would just defer to Mr. Reeves if there's any proof of any restitution payments that need to be made at this time, Judge, because I never spoke with Mr. Reeves after the plea was taken. So I don't have any receipts or anything for restitution. So I would just defer to Mr. Reeves for that. But other than that, Judge, there's nothing further from the people.
Mr. Reeves, would you like to give a victim impact statement?
I would.
You may.
Thank you, Ms. Bryant, Judge Bryant, if you would allow me to not only submit the paperwork, some of the paperwork, but I have a number of extra bills that are still recurring, as well as treatments that still need to take place because of the nature of this incident. And I thought you would be here in person, so I have this all tangible, as well as the actual photos, as well as videos of the procedures that I had, the surgeries, at least 7 surgeries that I had to take or have because of Ms. Green's action. Judge Bryant, if you would just give me a moment to explain what happened. Ms. Green was asked repeatedly to drop her 8th grade son off to the middle school door at John R. King. After 4 or 5 times of Ms. Green pulling her car all the way up to me while I'm taking children out of their cars and walking them up to the sidewalk, Ms. Green purposely drove around all the parents in line waiting to drop their kids off. And she repeatedly pulled up on me with her car. After the first few times, she was verbally warned. She was asked the first time to please stop. And I even gave her directions on where to drop her 8th grade son off. But she repeatedly kept driving around the parents that were in line and purposely pulling up on me in the parking lot with her car, to the point where this last time she was unable to stop in time, and I ended up having to push off of Ms. Green's car. If I did not do it at that time, I would have been on top of the car or up under her car. At this point, Ms. Green was asked to stop. She continued to go on and just do reckless actions with this car. I reported it to my principal. I even reported it to DPSCD. Ms. Green was asked not to even come to the school. We even had to go through the process of getting Ms. Green banned from the school because she kept doing reckless actions towards me. I don't know no other way to try to ask for reconciliation, because the time that I'm still suffering, I'm on a scooter right now, Judge. I'm still going through, getting ready to go through physical therapy. I just had my last surgery where my ankle was fused because of Ms. Green's action. I heard you all say 1 week of probation or something else, but Judge, I honestly believe that there needs to be more accountability to Ms. Green's actions. This happened back in 2019. It's June 2023. I'm still suffering from Ms. Green's actions. I am asking, and I'm willing to submit these papers with some of the weeks that were lost in my work, where I had to take off because of surgeries and I was denied workman's comp with DPS. I'm still paying everything out of pocket. I've lost my other job and streams of income, not only speaking, but traveling and making sure that I can get to my other responsibilities with doing youth consulting all around the country. Ms. Green's actions have changed my life completely. I don't know any other way to express myself, and please just forgive me if I'm sounding emotional, because I am. This is my first time even coming close to even having an opportunity to address this situation in a professional manner. I'm still suffering from this injury that Ms. Green caused. I'm asking, Your Honor, that it's just not probation and anger management, but just as I had to sit still and recover for years now, I'm asking that Ms. Green suffered jail, not suffer, but has had to render jail time, because just like I had to sit still, maybe she needs to sit still and be behind bars along with paying me back all the money that I have lost, as well as the money that I'm still coming out of pocket on. I can understand if this was an accident, but this was not an accident, Judge Bryant. Ms. Green was asked to stop with the reckless foolishness that she continued to display at John R. King. That's my place of work. This is how I make my living. And for her to come and just continue, not only disrespect the school, not only disrespect the kids, but put myself and the kids in danger. Yeah, I don't know any other way to express this, but there has to be some kind of accountability, because the actions that Ms. Green took, I don't know what else to say, but the best way to stand up to a bully in a situation is to say enough is enough. So, Judge Bryant, I don't know what else you would need from me. I have paperwork, I have pictures as well as videos, but please, I'm asking you, do not let this situation just be a slap on the wrist. I am still suffering. This is gonna be this has been a life-changing situation where I am affected for the rest of my life. My ankle is now fused. It took me, I started at 3 a.m., just for example, I started at 3 a.m. this morning because of the rain. Judge Bryant, what I'm asking you is, Ms. Green can never pay me the amount of money that I've lost. She can never replace the amount of time that I've lost, the engagements that I've lost, the time with my family, friends, as well as the schools, as well as their different positions that I now have to try to readjust my new way of life now. I'm asking, can you please speak up for me in a tangible way where Ms. Green will know that this is not okay at all. I need your help. I need justice. That's what I'm asking for.
All right, thank you, sir. Ms. Stevenson, anything on behalf of the defendant?
Thank you, Your Honor. Because of the nature of the plea, Ms. Green was advised not to make a defendant's statement, Your Honor, and that was her right not to do that. We did offer a no contest plea, anticipating that Mr. Reeves might try to avail himself of civil proceedings in order to be made whole, and which we would argue would is arguably appropriate here. Ms. Green, according to the pre-sentence investigation report, has absolutely no prior criminal history, Your Honor. And you just don't want to get into everything that's involved here, because this matter may proceed to civil litigation, Your Honor. But we're here charged with a misdemeanor, convicted at this point of 2 misdemeanors. Ms. Green with no prior criminal history, employed at this time, having no contact with the complaining witness, having no contact with the location of the incident, ready to accept responsibility for her actions. We trust this court to fashion a sentence which does give Mr. Reeves justice. There is another form whereby he may be made whole, even though Ms. Green does understand that because of the no contest plea, she is expecting some type of restitution, Your Honor. But there is a forum whereby Mr. Reeves may be made whole. And Ms. Green has no prior criminal history. In addition to deterrence and rehabilitation, definitely, I believe, is one of the goals of this court. And I don't see any reason why the sentence recommended by the probation department would not give the court, should Ms. Green comply with those conditions, assurances that she won't be back here with these types of charges in the future. So I'm asking the court, if it's not inclined to follow the probation department's recommendation, to follow Ms. Ritter's recommendation, Your Honor. I did just want to point out, I know that in her conversation with the probation department, Mr. Farmer was left with the impression that Ms. Green was somewhat evasive. And again, I would ask the court to hear my reason for that, which again is the advice of counsel, because this was a no contest plea, that she should definitely not try to hold back any information that the probation department would need to make a sentencing recommendation, but just not to get into the facts of the case, because it was a no contest plea. Ms. Green has been completely cooperative with me throughout this entire process, ready to bring this matter to its lawful conclusion, hasn't violated any of the court's conditions, Your Honor, with regard to having no contact with the complainant. And I'm asking the court to follow the people's sentencing recommendation.
Would Ms. Green like to make a statement on her own behalf?
Ms.
No,
Green?
ma'am.
All right.
No.
Well, Ms. Stevenson, as you can see, Mr. Green is sitting on the screen. Mr. Green, can you unmute and just put your name on the record and tell me if you're related in any way to Nicole Green?
Yes, Your Honor. No, I am not related at all.
All right, and your name for the record?
Yes, Demetrius Green, Specialty Court Case Manager.
All right. So when I read the pre-sentence report and then as I sat here to listen to the complainant, who I apologize, whose name has escaped me, but I was thinking to myself, maybe this was an epic fail on behalf of the warrant unit in the prosecutor's office. Now, I don't know what process they go through when they issue the warrant, particular warrant. I was looking to see if this had started out as a felony, right? I was looking to see if it had to start out a felony, and it didn't. And then I'm reading, and then I'm listening to Mr. I'm gonna tell you his name in a minute. I saw it on here. I'm listening to Mr. Reeves, and I'm saying, well, why did the prosecutor's office charge this as something having to do with an accident, as opposed to a felonious assault with a vehicle? That's what I was thinking. I was like, this should be, I don't know why you shaking your head. Yes, Ms. Green, because that's against you. Felonious assault, I think that's like a 10-year felony or something. I don't know. And then this one of them, okay, so I'm saying that for a couple of reasons. So I don't know what the process is that the warrant office of the prosecutors, the warrant division of the prosecutor's office goes through. I feel like if they had interviewed Mr. Reeves, that maybe they would have charged differently. That's how I feel. That if they had interviewed Mr. Reeves, that perhaps they would have charged differently. Because I'm sitting here saying it started out as failing to stop at a personal injury accident, which also says to me that she hit him and ran, a hit and run. So she hit him and she didn't stop. And then, y'all do what you do and negotiate it down to failing to report an accident. Now, I'm going to say that I'm a little disheartened by the way it began in terms of charging and the way it ended in terms of charging. And if what Mr. Reeves said is true, this was sorely, severely undercharged by the prosecution. And and that's disheartening. And then let me tell you what I observe. Let me tell you what I have observed today, and the last time we were here. I observe and I feel like Miss Green could care less. That she could give, I need you to stop being so animated, sir. I observed that Miss Green could care less. That she is aloof. She is not contrite. She is whatever she is. And I am feeling like I almost am not going to accept this recommendation and give her an opportunity to go back up to the original charge, if she chooses to. But I'm also, the reason I asked Mr. Green to come on is because I'm thinking to myself, a person has to be almost mentally ill for me to hear what I heard today. You know, I always say this right here. And I've even, I think, told you all this story. I don't know if I've ever said it on the record, but I know I've told it to the attorneys, like off the record when we're having our little, you know, post-court chat, of how I almost hit somebody and how it devastated me, how I was crying at the thought of almost hitting somebody. Yet Miss Green appears on my screen and she did hit somebody. And if that baby shake her head, no, one more time. If she shake that head, no, to the left or to the right. No, one more time. And that's exactly what I'm talking about. That right there is exactly what I'm talking about. Exactly what I'm talking about. And so I want to believe that the reason she is acting in this way is because she has some type of mental illness or mental disorder that she needs to have addressed by the specialty court, which is why I brought the specialty court coordinator on here. There, according to her self-report, she doesn't have a history of mental illness. But everything that I see says that she either is mentally ill or she needs to be in prison. Let me tell you that. So from what I see, I say she's either mentally ill, has some type of mental disease or disorder, or she needs to be in prison, and the prosecutor should have charged her with, at least at a minimum, felonious assault. Perhaps they should have charged her with assault with intent to do great bodily harm less than murder. Or perhaps they should have charged her with assault with the intent to murder. So while she coming on here with this little lackadaisical attitude, I had to admonish her this morning about her, how she's standing, how she's putting her ear up to the phone and whatnot. It's ridiculous, it's appalling, and it's offensive. And I agree with Mr. Reeves. I agree with Mr. Reeves. I agree with Mr. Reeves. But where I disagree with Mr. Reeves is that this is simply a misdemeanor. It's a misdemeanor. And it's only punishable by up to 93 days in the Wayne County Jail. Now she's on the verge of getting 90 of the days. But I'm gonna give Miss Green an opportunity to talk to Mr. Green, who says they are not related. So, and I don't have any reason to believe they are. I just always ask when it's the same last name. And she can hear what he has to say. At a minimum, she's gonna have to submit to a mental health evaluation before I will agree to her sentencing. You see what I'm saying? She done raised them eyebrows already at the top of a mental health evaluation. So, because I know that if I don't accept this recommendation, Ms. Green has a right to withdraw her plea, she might be withdrawing her plea. Because I'm appalled. I'm offended. I'm appalled and offended that it was charged so low. I'm appalled and offended that she has come in here not realizing the blessing that she has got with it being charged so low. I'm appalled and offended that she shows no remorse or contriteness, whether she did it intentionally or by mistake. The fact that she's here and has accepted this plea says to the court that at a minimum, she agrees that there's enough evidence to prove that she was the one that hit him. And so your attitude sucks. And since it appears to me that she must have some mental defect or disorder that is not allowing her to show any empathy for running over a man who has now had to endure surgery after surgery after surgery. If I was the cause of that, if I caused that to somebody, whether I intended it or not, I would be contrite. I would be so sad and sorry. I would be like, I am so sorry. If I didn't say anything else, notwithstanding a no contest plea, notwithstanding that Mr. Reeves may sue me civilly, I would say, I'm so sorry that happened to you. I'm so sorry that you have had to endure these surgeries. You're offensive, Ms. Green. Your demeanor with respect to this situation, it's offensive. I'm going to let her talk to Mr. Green. It is my intention, as I indicated, at a minimum, she's going to have to submit to a mental health evaluation. Because if she passes that mental health evaluation and they tell me, no, she just whatever, and she doesn't need mental health treatment, because there's nothing in her report that says she needs mental health treatment in terms of her self-reporting, but nobody gave her a mental health evaluation. If she is not a candidate for mental health treatment court, I'm going to tell you right now, she's going to jail. She's going to jail. And I'm going to write a letter. I'm going to find out from the state court administrator's office if it is inappropriate for me to express my displeasure to the prosecutor about how they charged this case. It's appalling to me. It's appalling. Based upon the police description of the incident, it's appalling. I'm going to send Mr. Green and Miss Green to breakout room.
Judge Bryant, if I may interject, so if Miss Green is self-reporting that she does not have any mental issues,
She don't qualify.
yeah, that would be a non-qualification.
Yep. We can't check it out.
So I do not have the ability to make a clinical assessment. That would be required by a licensed practice assessor. We do have a clinical assessor on our team. However, she is not in the office today and she is working from home, so I'm not sure about her availability in this moment, but if we would like
Alright.
to schedule something with her, we can make that happen.
Okay, yeah, let's do that. All right, so this is what I'm going to do. I'm going to adjourn the sentencing. I want Ms. Green to submit to a mental health assessment. And then I'm going to set the sentencing for in-person. And that in-person sentencing is going to be Mr. Green, how long, like, what, do you know anything about the availability?
So I do know in this next week, we will be traveling to a conference and we will
Right,
be gone
yeah.
all week. But
Right.
however, the week following that, we should be available that Monday. Specifically because I know Tuesday is going to be a holiday, July 4th. But yeah, we can probably get her done that Monday.
Okay, so let's see if we can schedule her for that Monday, and then I'm going to adjourn the sentencing to the following. Well, I want to make sure it's a day that I'm definitely going to be in person. Ms. Stevenson, do you know anything about the Hickman trial on the July the 10th? There is a 12 noon check-in. Well, I don't know the charge.
That's what you want to know what the charge is, Judge?
It's a bench trial. Mhm.
Okay, as to whether it would go or not.
Yeah, July 10th, that's Hickman. That's the bench trial.
Oh, Mr. Flanagan, can you help me, please?
Well, you know what? Strike it.
Okay.
Because the Wilma Baker, I have a jury trial, Wilma Baker. It's not yours. It starts on July 11th. I don't even know that attorney. I'm going to set the sentencing for July 11th. I'm going to adjourn the sentencing.
Excuse me, huh?
Yes, sir.
I was trying to see if I can, is it possible to do the following week? I wanted to know if I can be at the sentencing. I have a summer camp, it's a prior engagement that I run in Lake City, Michigan. It'd be a huge ordeal if I had to
Okay.
travel way back down to Lake City.
So
to come for.
that's that week I was just talking about?
Yes, ma'am. I do. It starts the 8th through the 15th, and I'm done the 15th.
Okay, thank you. All right, well, then I'm going to set the sentencing for July the 17th. No. I'll do it on the second day of the trial, July the 18th. That's at 9:02. And it is in person. So the assessment should be complete before then, and then we can address moving forward. Additionally, I'm going to indicate that should Ms. Green fail to appear on July 18th for the sentencing, she looked like she just froze up because she was walking and moving, because that wasn't her same background just a minute ago. When I first looked down, this not the background I had. So she walking and moving, and now she doesn't have signal.
I can, I think the phone may have died, but I can get her on the phone so she can hear if that
Not if her
pleases the
phone
court.
died, but go ahead.
Okay.
Because I want her to hear that if she failed to appear, her bond is going to be $30,000, 10% plus a GPS restricted tether.
She'll be here, Judge.
All right, well, I want to make sure she know that, but
It's just ringing,
I
Judge.
trust you. She probably something she moved.
Oh, this is her calling now. Just a second. Okay, Your Honor, I do have Ms. Green on speaker.
All right. Can she hear me?
Ms. Green, can you just say whether or not you're able to hear the judge?
Yes, I am.
Oh, now there she is back.
Okay.
Zoom. All right, so I indicate the sentencing is July 18th at 9:02. That's in person. And then if Ms. Green fails to appear, her bond is going to be $30,000, 10% plus a GPS restricted tether. Anything further?
Judge, one thing from the people, so by that date, does the court want the restitution information from Mr. Reeves?
Yes, so he says he has a packet there today. Do you want him to leave the packet there so that you could get it when you come to court next week?
If that's possible, Judge, I would appreciate that, just so that I can look it over and have the information available for the court when we're in person on the sentencing date.
All right, because we do have a trial next week, don't we?
Yes,
Tuesday.
we do.
We do, okay. So, so the folder that you were showing me, Mr. Reeves, leave that with my court clerk, and then the prosecutor, she's going to pick it up from you. So, Mr. Flanagan, put it in don't put it in the file. I don't want anybody else to have access to it. So what I want you to do is maybe put it in the file cabinet over there and lock it up.
Okay, yes, ma'am.
So Ms. Ritter can get it when she comes in. All right, anything further?
Yes, Your Honor, can I perhaps be placed in the breakout room to get Ms. Green's information so that I can have contact with her to set the assessment?
Yes.
Or
Oh,
Mr. I can
didn't-
get that to Mr. Green.
Okay,
Well, it's
that's
too
fine.
late. I already clicked close the thing out. I didn't see I didn't know Mr. Bird was still in there.
And actually, it looks like we just lost Ms.
Okay,
Green.
well, when Mr. Bird come out, I'll redo. Okay, so Miss Stevenson will make sure you have the information, okay?
Perfect, thank you.
All right, you're welcome. Thank you for telling me that if the people come in there and lie, they don't qualify for mental health treatment court.
Yeah, but we have a clinical assessor, so we should be able to get past that now, so.
All right, thank you.
All right, thank you.
All right. Mr. Reeves, you're all set until July 18th, sir.
Yeah, Judge Bryant, the rest of the bills that are still in the mail can still to come. Can I still submit those at July 18th hearing? I'm
Yes,
sorry.
try to get those to the prosecutor before July 18th.
The prosecutor name.
I have my cards in the courtroom. If the court officer can give Mr. Reeves my contact information, Judge, I'll speak with Mr. Reeves.
All right.
Thank you for hearing me, Judge. I appreciate you.
All right, no problem.
Hello?
Okay, I'm gonna take a brief recess. It's gonna be brief, about 3 minutes to stretch my leg, fill my cup.